Hey, welcome to another episode of the I Just Want This Done Divorce podcast. I'm your host, Rayford Palmer. With me is always Rahul Iyer. How are you?
Hey, good. I am the glasses-wearing Rahul Iyer today.
I was going to say, what's up, Four Eyes?
An unfortunate curse of having vision that's gotten worse over time.
I have glasses too. I don't have to wear them all the time. In today's episode, we're going to talk about a French woman who stopped having sex with her husband, wins appeal over her divorce, allegedly stopped having sex with her husband, I guess. We're talking about Pete Hegseth's divorce with his second wife on wife number 3 now, married to wife number 3. And we'll talk about non-disparagement clauses. That's kind of interesting. Then a bill that's been proposed in the Indiana legislature related to making people have a witness testify to the breakdown in their marriage. Jessica Simpson divorce news. So we got some celebrity divorce news. Then we're going to talk about parenting and custody fights. We're going to talk about Illinois focus because we're Illinois divorce lawyers in Chicago, but this is applicable really. There are analogous stuff across the country about how these custody things work. So we're going to talk about that. We'll talk about some details about how that strategy works with that and what to expect. And then also kind of a little interesting news item about children of divorced parents to wrap up the show. So let's get started. I want to talk first about this article. Lately in the news, there's been talk about a conservative movement to make divorce harder, actually. And it's interesting because folks have worked for decades trying to make divorce less difficult, to make it less contentious, and really make it easier for people so the costs are lower. There's less fighting. People complain that the expense of litigation is bad for families, bad for children, bad for women. There's a lot of this stuff came out of a women's rights movement. And I won't bore everybody with the history of all that, but most of the divorce legislation over the last many decades has come really out of women's rights movement and equal rights movement to make divorce less onerous and allow people to leave a marriage if they didn't want to stay in it anymore. That's the idea of no-fault divorce. So it takes one person to leave the divorce, which sounds pretty common sense. But other countries, and we're talking about France here, don't agree, and they still allow for-cause divorces. And some states in the United States still allow people to prove cause in divorce. We've talked about this before in other shows, and that might in some cases affect the financial outcome of a case, et cetera. So it's sort of interesting and timely that this decision came down right around the time this Indiana bill just popped up. So let's talk about this. So European Union Rights Court rules a French woman not at fault in divorce for refusing sex. So this actually is a big deal, apparently, in France, the way the law works. So here's the story. A French woman who has stopped having sex with her husband has won an appeal in Europe's highest court after being told she was at fault for the divorce. This case was filed in 2012. She claimed in that case that her husband was at fault, said he was bad-tempered, violent, and abusive. So cause is still a thing in French divorces. They had 4 children together. She said she stopped having sex with her husband in 2004 over health problems and threats of violence. He counterclaimed, so he filed a lawsuit in the other direction, that she failed to fulfill her marital duties and made slanderous accusations against him. Okay, in Illinois, you can counter petition. You file a divorce petition going the other direction, but we don't have cause. We just have irreconcilable differences. So we can't throw bombs at each other in our divorce cases anymore. In other countries and other states in the U.S., you can. So this case took forever. So in 2019, this case apparently went up on appeal. The woman was told by a French appeals court her refusal to have sex with the husband was a breach of her marital duty and ruled she was responsible for the breakdown of the marriage. Now, we don't know what that means in France, meaning what the impact was of being the cause of the divorce. I'm guessing there's some financial impact, et cetera, but it doesn't say in the story. But the interesting thing is she appealed to some European Court of Human Rights. And I won't get into the political stuff about this European Union court sits on top of countries' own courts and makes legal decisions that impact those people, and they don't get a vote on who's over there in that European court. Pretty interesting. But so this European Court of Human Rights ruled the French court was wrong to make that decision, condemned it for violating the woman's right to respect for privacy and her family life. It said on Thursday, and this is a quote, "It could not identify any reason capable of justifying this interference by the public authorities in the area of sexuality, and any concept of marital duty needed to take consent into account." And so they talk about this idea of marital consent or consent to sex by getting married. Apparently in French law, there's a concept that when you're married, your spouse default consents to sex. Now, I'm not sure about the intricacies of how that all works, but this European Human Rights Court said, in the court's view, this is a quote, "Consent to marriage could not imply consent to future sexual relations. Such an interpretation would be tantamount to denying that marital rape was reprehensible in nature." The court concluded the very existence of such a marital obligation ran counter to sexual freedom, and also France's obligation to combat domestic and sexual violence. Apparently, France is considering amending its rape laws because, as you may know, in the United States, I'm not sure how many states, but I know there are exceptions that there is such a thing as rape in marriage, and it is a crime in many states, if not all the states. I don't know. I haven't had time to do the homework on that. But in the U.S., we're much more enlightened about that issue. What's interesting is the attorney for the wife said they hope it marks a turning point for the fight for women's rights in France. The lawyer said it's imperative that France, like other European countries like Portugal or Spain, take measures to eradicate this, what she calls rape culture. This is a quote, and promote a true culture of consent and mutual respect. The interesting thing it says is the impact has no ruling on the divorce itself, but it will prevent French judges from making similar divorce rulings in the future. So then it says a diplomatic source told Reuters the French parliament is currently considering a new law that would modify the definition of rape legally. So really interesting case, points up for-cause divorces still alive and well in other places. And this idea that is foreign to us, that there would be this sort of permanent consent concept in marriage in other countries to sexual relationships, and that's sort of a new idea or being challenged in Europe. So just an interesting counterpoint to what's going on in the United States, where the laws have been quite progressive and gotten to much more balanced rights between spouses. And now at least we're hearing about push towards making divorce more difficult. So, and one thing I'll point out is this case took years and years and years. So I don't know what the outcome was in the divorce case itself, but it was a very interesting story. So I wanted to mention it. I don't know what the other European countries do with this issue, but we don't know the evidence. We don't know the testimony about what was going on in the case. So when he said she didn't fulfill her marital duties, which I think it means sex, and made slanderous accusations against him, that was like his reason for the divorce. And then she said she did it because he was abusive, and that's why she stopped having sex with him. So really interesting situation, like I said. So turning attention to our country, what about this divorce decree with Pete Hegseth? I know he's in the news right now because he's in the running to be Secretary of Defense in the Trump administration. And there's been some negative stuff out there from family members. Like recently a story came out, I think it was a sister-in-law of one of his ex-wives, I believe. Don't quote me on this, said he was drinking too much, etc. There's been some stuff like that out in the press. And then you came across this story about this non-disparagement clause.
So it's a very topical point here and sort of highlight more issues that we frequently see in our world. And for the viewers or the listeners, this isn't a political conversation or discussion. It's just tied to the current politics. So he was nominated, like you said, Rafe, for Secretary of Defense, and he is testifying before the Senate Armed Services Committee, and was asked about NDAs, or also known as non-disclosure agreements, that stemmed from his 2 divorces. He responded that he wasn't aware of any NDAs. However, court records show that when he was divorced from his second wife, Samantha, in 2018 in Minnesota, their settlement agreement included a court-ordered non-disparagement clause, barring both parties from making certain comments, etc., specifically as set forth in those agreements. So the question becomes, and his lawyer, I'm summarizing this, right? So his lawyer essentially argued that a typical non-disparagement agreement in a divorce, especially involving kids, is not the same as a standard NDA. And so the question then becomes, what are these non-disparagement clauses? He had non-disparagement clause in his parenting agreement with his kids, saying neither party shall talk badly about the other party in front of the children or allow third parties to talk badly about the other party in front of the kids. I thought that was a very interesting topic. And I don't believe that that's an NDA insofar as the traditional nature of an NDA. But B, I thought it was interesting because a lot of people don't know that such non-disparagement clauses exist. And the reason for it is, as we're going to talk about later in the episode today, you don't want to sort of wrestle in the mud about the other party, especially with the kids, try to brainwash them, because there's no end to it. And the kids will listen to what dad says, kids will listen to what mom says, and they're going to be all scrambled because they have no idea what's actually going on.
These are non-disparagement clauses that we see very typical in parenting agreements, very different than a non-disclosure agreement that has a lot more content. An NDA is a longer document that has penalties and things like that. A non-disparagement clause just basically says don't badmouth each other.
Right. And so his agreement actually further states that each will refrain from engaging themselves in any public discourse, including through either traditional media or social media, disparaging the other party. And it obligates them to take reasonable steps to encourage friends and family to refrain from doing so. So the second prong of that maybe getting a little closer to this NDA land, but it's going to be interesting to see what comes of that.
That's not a clause that we typically have in our agreements. That the extended part, the part we have is don't badmouth each other in front of the kids. And we might have something that says don't make third parties do it. Not surprising though, Hegseth was already a public figure by 2018. So it's not surprising that there's a little bit more robust language in there. And, these are negotiated deals, folks. Like she got something in this deal and he wanted to buy silence. It's also a two-way street. He can't badmouth her. Yeah, and she agreed to that. So, Rahul, is the angle in the story that that's somehow controversial, or what's the thrust of this story?
Yeah, the thrust of the story is this sort of fight between whether or not he lied during his testimony by saying he had no NDAs when in fact he had this non-disparagement clause. So that's really the angle, is which one is right? Did he or did he not? No opinions on our end here, but I'm just saying it's definitely a good argument, but he's also got a good defense.
I give the guy a little bit of a pass because they said NDA. He hasn't seen this thing in 6 years, this settlement agreement. He's not thinking about it. He's like, I signed this thing. You know how it is. These agreements are 20 pages long. The MSA is 25 pages. The marital settlement agreement's 20 some pages. Parenting agreement's 15 or something. They read them over, sign them, and they don't want to think about it again. And I'm sure he didn't think there was anything unusual about the not bad mouthing clause and probably promptly forgot about it. And then he got divorced another time. That one, I cut him some slack. That's some gotcha stuff. And I don't know whatever side of the aisle you're on. Again, we're not picking sides. It just, if you put a D behind his name and you said he's okay, ask the same questions, the folks on that side of the aisle would say this is minor, no big deal.
It's just one of those, like you said, it's a gotcha moment and trying to sort of throw the kitchen sink to see what sticks, what doesn't stick. But it makes for interesting just from that one perspective of, what is a non-disparagement clause in such parenting plans, right? That's kind of what we're trying to focus on.
This would not be unusual for celebrities or high net worth folks to get something like this in their agreement. We'll turn our attention to the Indiana divorce bill. And this popped up in the news recently. We're recording this in late January 25, and this bill was introduced recently in Indiana House. It's just going into committee. So this is not a law. For those of you who watch Schoolhouse Rock, this is just a bill. This young male legislator introduced it essentially to give a little comparison. Indiana is pretty similar right now to Illinois. They allow irreconcilable differences or no fault divorce. And all it takes is for one of the parties to plead in their petition that irreconcilable differences exist leading to an irretrievable breakdown in the marriage. All it takes is one party to testify to that. If one person says, isn't it true that irreconcilable differences have led to an irretrievable breakdown in your marriage? And they say, yes, that's enough to get a divorce. And you have to be separated and apart for 6 months. We ask that question. That's Illinois.
As long as you think if irreconcilable differences have occurred, that's all they need. The judge won't ask the other side, hey, is that true? And you also don't have to be separated for 6 months physically, like in a different house. Emotionally, mentally, I can just say I feel like I've been separated for 2 years. Since the day after the marriage, I've been separated mentally. I'm being sarcastic, but I mean, there's no test for that to confirm that.
The other party's not allowed to testify. They don't get to come in and say, no, it hasn't broken down. We're great. And they don't get to contest that. So all it takes is one party, and then that's it. In Indiana, that is also true from my quick read of their law. So this bill is interesting because it says that a court can only grant a divorce, and I'm reading the statute, at least one party presents a witness at the final hearing on the petition who testifies to affirm the irretrievable breakdown, or the parties show cause as to why the petition should be granted. Either they have to have a witness testify that it's broken down, or they have to prove to the court why they should be divorced. I'm assuming, because I'm a trial lawyer, theoretically they could stipulate, or if they agree there's a breakdown in the marriage, that would be admissible into evidence, and they probably wouldn't need a witness. It doesn't say that in the statute, though. It says they need to present a witness. And it also opens the door for more than one witness to come in and testify about this. The witnesses permitted are the officiant of the marriage. So you have like Father Jones come in. That's interesting. Number 2, an individual who is assigned witness to the marriage. 3, a parent or sibling of the party. 4, a friend of the party who's known the party for at least 60 days. So they go, yeah, the marriage is really, really dead. A religious leader with knowledge of the marriage, or a licensed counselor. And they can't accept payment. So there's a bit here that says an attorney representing a party cannot testify to this, or an individual in that list who's received any form of compensation. That is essentially the law. The proposal is to amend their divorce law to require this. So it's interesting because it's sort of a step backwards from making divorce easier, it's making it harder theoretically. And I've read some pushback on this saying, well, it'll probably just be a formality. And I don't know that the legislator who's drafted this thinks it's a formality. I think he wants this to be law and have teeth. And this hasn't been gone through committee yet, and it's going to go through the mix master, and who knows if it'll survive committee or how it comes out of committee. But it's interesting because it's been cast in some press reports as like Project 2025. There's like been a political bent attached to it. The proponent of the bill, he says it's not meant to be political. He's intending to make it harder for people to get divorced because he said the story went that the legislator saw a couple getting divorced in court and saw them casually testifying to the irretrievable breakdown of the marriage. And he was upset about that and said, well, they should take something like this much more seriously. One incident should not be the basis of, passing legislation, in my opinion, but also he doesn't know what those people have gone through or are going through. And by the time folks get up to the court to testify about their divorce, they're exhausted and they just want it done. When people go there to testify, it takes about 10 minutes to do what we call divorce prove up, maybe 15. And you answer this list of questions because you have to put in testimony for the court to find you get a divorce, to grant you a divorce. And part of it is there's irretrievable breakdown in the marriage. And this is similar to Illinois. And so there's this brief hearing. Well, it's pretty routine. It's rote stuff. The lawyer asks you a series of questions and you answer yes, no, yes, no, yes, no. And the lawyer's upset that it's like casual. Well, he wasn't there in the years these people were struggling over their relationship and the counseling they may have gone through and all these other things. So I guess my pushback on this is he says the intent is to help children, and families. You're not really going to do that by adding this. There are two problems I see with this. Either you're adding a speed bump to the divorce process, which is just kind of like a step that lawyers are going to have to fill out another form, or you're creating something that could be used by an abuser or person who's into coercive control to use as a weapon to prevent someone from getting divorced who may be a victim of domestic violence, etc., or a foot dragger who's just using this to their advantage to manipulate the situation and refusing to get divorced. So I think this may have been well-intentioned, but the shape of it is problematic. And it's almost because it has this party showing cause as to why the petition should be granted, you're drifting back into for-cause divorce. And I think that's concerning.
I have a few thoughts on this. Number one, I do think, as much as he might say it's not politically motivated, I think it might be where you can't just bring back for-cause divorce and say, well, now we're going to have for-cause divorce. So let's take baby steps. What do we do here? Let's first put this up here, see what happens, see how people feel it out, and then slowly start ramping it up. Well, now that you have this little speed bump, let's create a little bit more of a roadblock here. And then let's kind of get up there. And you know what? Since we're doing all this, let's get rid of all these things and let's just say, just prove a cause or create a reason for fault, and then we'll give you your divorce. So it's almost like going back in time. And while you can't go back in time all the way, you can slowly start walking back. And I think it might be pretext to maybe bring back for cause divorces or start testing the waters to see how people react to such legislation. That's one thought.
In Illinois, we eliminated jury trials for divorces. We eliminated for-cause divorce because they created circuses. It was party time for divorce lawyers. And I don't want to blame our profession, but the parties are emotional. If one party wants to manipulate the process, there's nothing better than using for-cause, or one great way is to use for-cause divorce to embarrass the other spouse. Now you've got testimony about affairs. The old days weren't that long ago. When I was doing divorces early on, you could still allege infidelity.
2014 is when they really abolished it. So, it's not that long ago.
It could be really ugly. People would have private investigators follow people around. People would take depositions of the boyfriend or the girlfriend and ask questions about their sex life and all this super uncomfortable private stuff, just meant to poke people in the eye. There was nothing, because they could have still gotten a divorce by irreconcilable differences, because cause in Illinois doesn't affect the outcome. So they were just doing it to bash the other person, which is ultimately why we got rid of it. So you're adding all this nonsense to these cases just to beat up the other person and cost money, and then, so that's part of it. And then jury trials were allowed up into the 1970s in Illinois. It's still in some states, jury trials are still permitted. But I understand people not wanting to encourage divorce. I understand people wanting to dissuade people from it. But it strikes me that better ways to do that are better education before people get married. There already is a trend line to declining divorce rates because people are getting married older and I think wiser. And then in addition, if you really want to protect kids in divorce, then make a law that says folks have to go through mandatory co-parenting training. In Indiana, my understanding is there is no state law that requires that. In Illinois, we have that where courts put people through mandatory parenting training, which teaches them the impact of divorce on kids. Do something like that that's productive.
Genesis of this idea for his piece of legislature was that he saw someone at a hearing and they didn't seem serious enough. Like, what were they supposed to look like? Were they supposed to be weeping? Were they supposed to be jumping up and down, yelling, screaming? I mean, it's a court. You have decorum. You have to be very put together. And it's something that, like you said, they've lived through for a while. It's not like it was a surprise. And so I'm not really sure what the person was expecting to see, because clearly what he saw, he didn't see. So just a whole bunch of questions.
It'd be interesting to see what happens with this. If we get more information about it, we'll update people. Next thing we want to talk about was there's little news about Jessica Simpson's divorce. Simpson and Eric Johnson have officially split after 10 years of marriage. They announced their separation January 14th. Jessica Simpson released a good statement to the press. They're kind of following the playbook that we've seen celebrities follow, keeping it peaceful and encouraging co-parenting. Apparently they have 3 children, a 12-year-old, 11, and 5. It's unclear what the reasons of the split are. There's some press reports that the couple had been in a lull period for some time, that Jessica felt she grew while Eric did not. Who knows what that means? They tried methods to save their marriage, including counseling and spiritual healing, but were unsuccessful. Okay, well, good on them for making an effort. Oh, a couple footnotes. One is I have read conflicting reports. There is rumors that they don't have a prenup, which is wild because she's worth a couple $100 million and he's worth like $10 million. And that would be a big deal if they don't have a prenup. Following like on the heels of Affleck not having one with J-Lo. The one thing I thought was funny was Kim Kardashian has reportedly stepped up to help Simpson through this difficult time. I don't know about you, but I don't see Kim K as like the counselor extraordinaire or the divorce coach that I'd be choosing to help me navigate this. But hey, everybody's got to find their support structure. They both requested privacy as they navigate this period in their lives. So I'd read elsewhere that it wasn't known who their attorneys were or if they'd hired them. And my understanding last I knew was no case had been filed yet. There'll be more on this, I'm sure, in the future. If they do it the way where we follow the celeb playbook, they'll keep it all quiet. They'll negotiate something through mediation or collaborative behind closed doors. And then the next we'll know about it is there'll be an announcement that they filed and got divorced.
It's official, folks, is what the headline will say. They're divorced. As of yesterday, the judge entered their decree and they're sharing parenting time, and this is how it's being done.
Yeah, we're not going to see details like we do with like when we saw Kevin Costner, where there was some litigation and that there was grist for the press mill because they can pull the pleadings and read them. And so this is going to be, I think, more along the mold of the typical celeb divorce where they keep it on the down low. So good for them. Hope it works out and they pay attention to the kids. That's 3 little kids. They need their parents. So before we move on, I want to just talk a little bit about our firm briefly. So we both work at SDG Divorce Law in Chicago and in the Chicago area. We've been in business for over 30 years and we serve folks all over Chicagoland who need help with divorces, prenups, postnups, and parentage or paternity cases. We also help people with modifications of their court orders from these cases. So please consider our law firm, SDG Divorce Law, for all those types of needs with family law. And if it's something we don't handle or if it's not in our area, which is Chicago and the suburbs, we will refer you to somebody else who's excellent. We have a referral list of great lawyers from all over the country and Canada. We're happy to give you a referral. So please consider us. Our law firm's website is stglawfirm.com. That's stglawfirm.com. We're very easy to find on the internet just by Googling us. And I'd be remiss if I didn't mention my best-selling book, I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids' Money and Minds, available on Amazon, Audible, and where all great ebooks are sold. It's in all formats, hardcover, softcover, Kindle, Nook, and I did the audiobook narration myself, and it's on Apple Books. You can find it anywhere. The gist of all the advice I've given clients over the 20-plus years I've been doing divorce, everything I distilled into this book to help you navigate divorce. This is not some dry, boring recitation of facts or something that should be on a website. There's 300 pages of quality in this thing, 8 hours in the audiobook. It's all the things I've told clients over the years based on real life experience to help them navigate divorce and help them understand how divorce lawyers and divorce judges think about these cases. Then the key concept here is a cost-benefit analysis. That is understanding what it takes to get divorced, what your chances of success are, being realistic about that, and then understanding what it's going to cost you to get from A to B so you make the best decisions for you and your family. Check it out. It's a bestseller on Amazon. Great reviews, almost 100 reviews at 4.7, and rated the best family law book of all time, still by Book Authority. The book was published in 2021. So 3 years straight, still a bestseller. This is the book on divorce. There is a website for the book. It's IJustWantThisDone.com. You can also just search my name, Rayford Palmer, and you'll find all the stuff about me in the book. So thank you. Then also, I'm writing a new book. It's going to be released hopefully around March 1st. It's called I Just Want to Know How Smart, Successful People Decide on Divorce Without Fear, Uncertainty, and Doubt. And that book's exciting for me because it's the book I wish I had in 2014 when I was struggling with my own decision to get divorced. And this is the guidebook for you if you aren't sure what to do. If you are unhappy in your marriage, if you're concerned your spouse is unhappy in the marriage and you think maybe they want out, this book will give you step-by-step guidance with no steps skipped about what to do and who to talk to before you start, before you bail out of the airplane. Do these things first. That's what the book is about. So Rahul, let's talk now about kind of our legal topic for the day, or substantive one, which we want to talk about parenting, custody, visitation disputes.
Absolutely. I think it's important to first know, what are we talking about here? You may or may not have heard other episodes of ours where we've touched on these kinds of concepts, but just as an initial sort of backdrop, custody and allocation of parenting time, allocation of parental responsibilities, visitation, these are all like terms that people often throw around. We could use custody, you could use allocation of decision making, parenting time, visitation. All of this basically boils down to two big concepts. Who can make decisions for the kids that are significant related to education, religion, healthcare, and extracurricular activities? I'm not talking about day-to-day decisions here. I'm talking about those four decisions, meaning are you going to do it yourself or are you going to do it jointly with the other parent? And how much time do the kids spend with each parent? That's really all we're really talking about. Those are the two fundamental issues. All the other stuff, how much vacation time, who gets what holiday, how much telephone time. Those are all like fillers. These are the two big blocks that you got to figure out. And so I think this is a good discussion here. What we want to talk about is, well, it's easy to say this is what you have to figure out. How do you figure it out?
One distinction that I think we should make is, don't people frequently conflate visitation and custody? They'll say the word custody in a way that's like ownership. You've talked to clients before and they say, I want custody of the kids. And you get this feeling that they think it's like they're going to own the kids.
Well, they're going to own the kids and they're also going to win, right? Or whatever it is, I want custody or I need to have custody. Well, at least in Illinois, again, conceptually, this might be very similar to other states, but legally, Illinois and other states are similar in certain instances, not similar in other instances. So I tell clients, look, custody is a label, and it's a label that's no longer existing in Illinois law. So in 2016, the law changed where they got rid of the word custody from the Illinois Marriage and Dissolution of Marriage Act, literally gone. So you will not find a reference to custody unless it relates to something that says formerly known as custody or something like that. The state, essentially, the legislature found that people were fighting way too much about wanting that label. They wanted legal custody. They wanted physical custody. Sure, I'll give the other side half the time, but I want custody. It's like, well, what does that mean?
And one little footnote that's a little technical, but it's Illinois specific, was if you had, it was called primary custody or residential custody. I heard those terms kind of batted around back then. Started doing divorce in 2001. And if you had primary, and typically it was mom, even if the other parent had 50% of the parenting time, the person with residential or primary actually had some superior rights over the other person, even if it was a joint parenting agreement, meaning what we used to call joint custody. Now it's shared allocation of parental responsibilities, but it wasn't really 50-50, meaning there were one major thing that the parent could do that was changed a couple ways was they could technically move anywhere inside the state of Illinois without restriction and change the school for the child. So they could change school districts and move somewhere else, and the other party really couldn't do anything about it unless there was some agreement in their divorce decree restricting them in some way. And so you would think, well, that doesn't moving and changing schools, isn't that really a custody decision that should be shared? And that's not how it worked. If you had primary, you had kind of a superior right unless somebody modified it in the parenting agreement. And the idea of the law was to take that out. And the concept of custody, make sure that was clear to everybody that it's really about decision making for the children, responsibilities, rather than some ownership of like a thing like property.
The court is designed to give both parents tools they need to work this out amongst themselves initially. The court doesn't want to get involved unless they absolutely have to get involved, because sometimes it becomes so convoluted and you can't just undo something like you could in a Word document. Once it's there, and it's just going to start. And I know you have a saying for that, and we'll get to that here in a second. But the courts first mandate that both parties have to take a parenting class. co-parenting class that talks about, like you said, parenting training. Basically, how do you co-parent now that the marital relationship or the romantic relationship is no longer there? How do you co-parent these kids effectively? The second one is mandatory mediation. Both parents are required to go to mediation related to these issues, parenting time, decision making, etc., to see if they can work it out. The court wants to let the parents work it out with a neutral third party before the court has to step in. If all that fails, you can work out all of it or you can work out most of it. Whatever's not being worked out, the court unfortunately has to resolve.
We still use the term custody and visitation just to make it simple for people because, like you said, it's a mouthful. So, and then there's this idea like, I want the kids to be with me, and it's understandable. Or if they really have a bad blood in the relationship, some folks come to us and say, well, I'm okay with 50-50 parenting time, and we're going to live close by and all that, and they're doing well. But the people that are angry with each other may not be the case. And one of the things we work hard to explain to people is custody and visitation are two separate things. Custody is who makes the decisions for the kids about healthcare, education, and all that. And visitation is how much time are you spending with the kids. And one does not mean the other. Technically, a person could have sole decision-making or sole custody, and the other parent could have 50% of parenting time. And we try to make people understand that they're two separate concepts that work together. So you want to find out what the fight is really about. What is underlying when somebody says, I want sole custody? Do they want most of the parenting time? Are they worried they can't make decisions with the other spouse? Yeah. Why? Digging into that, we're explaining this today to help folks understand these ideas ahead of time so you can better talk about these things and think about them with your attorney and not get sort of bamboozled into fighting over something that when you don't know what you're getting. And you might spend a fortune and a lot of time and heartache. And when you quote unquote win, it's a Pyrrhic victory, you lose. It's not what you expected at all. So helping people understand those concepts is important. What happens, Rahul, once they do the parenting class? They do the mediation doesn't work out. They can't reach an agreement. Now, by the way, most people reach an agreement, folks. Not necessarily a mediation. That's usually a little early, but most people negotiate a settled case. 95% of these cases settle at some point, but there are cases where people just can't work out an agreement. And what happens next in a contested case, Rahul, at that point? And we're talking about Illinois, your mileage may vary in other states.
Mediation doesn't work or doesn't fully work, meaning you've either resolved none of the issues or you resolved some of the issues, but the two big ticket items still stand, or the one you agree you can make joint decisions or you can have joint custody, but you don't agree on how much parenting time or visitation the other person must have. So then the court will likely appoint what we call in Illinois a guardian ad litem, also, abbreviated as GAL. You might hear the letters GAL thrown around. A guardian ad litem or GAL's role is to serve as the eyes and ears for the court in an investigatory capacity. Your judge can't go to every single person's house who appears in his or her courtroom and talk to you guys and do all these things. So they want someone they trust, someone who's gone through the appropriate training with the experience to do this investigation on their behalf and then come back to court and report on their findings and their recommendations.
Like the court's not going to interview the young kids, right?
Right. We have had cases where they do in very, very exigent circumstance, but 99.99% of the time they will not.
Yeah, or they'll interview older kids, and it's called an in-camera interview, which doesn't have anything to do with cameras. It actually, there are no cameras.
Yeah.
In-camera means in the court's office, so in the judge's office. And obviously that's kind of scary and intimidating. Generally, if that ever happens, it's with older, like teenage kids, and it's very rare.
And so this GAL will talk to both parents, depending on the age of the kids, talk to the kids or watch the kids, observe them with each parent, maybe go to each parent's house, talk to friends, family, maybe look at school records, health records, doctors. Whatever needs to be done, they'll do those things. They'll also ask for what each parent wants, each parent's response to what the other parent wants, and take all this information and distill it into what they believe from a neutral perspective should happen for that issue. They could say, you know what, there's no reason both parents can't have 50-50 here. One party just wants the control of having 51% or 52% just because they think that's right. Or they'll say, look, as much as both parents buy in, frankly, one parent just can't make the 50-50 happen. They're too far away or they just don't have the lifestyle for it. So they just get their weekend time.
What are the limits of that power? And is their recommendation binding? So sort of part of that. And then can you get rid of a GAL you don't like? If you could kind of answer those.
Yes, absolutely. So a GAL has a lot of power. They are not the judge. They don't get to make the decision. They make the recommendations to the judge, and the judge has appointed them specifically because they trust them, and they will more likely than not listen to the GAL's recommendations and incorporate them in some form to a final order. Now, just because the GAL says something, that does not mean that that's exactly what a judge would do. A judge can listen to things, listen to other testimony, and also deviate from what the GAL says. If you don't like a GAL, more likely than not, they're not going to get out. There are ways to remove a GAL from a case, and that happens every once in a blue moon, but it's not because you didn't like their recommendation or you thought they gave you a weird look or they don't agree with you, things like that. Yeah, it's got to be some conflict of interest or bias, and not just bias because they don't agree with you or they don't take your side. It's got to be a bias that can be proven.
It's got to rise to some kind of impropriety. The term I use is you got to get the judge excited about it. It's like with dissipation, if we talk about like waste of marital assets, we talk about this issue, like getting rid of a guardian, you've got to have some stuff that gets the judge hyped up. Like the judge has to get angry and say, yeah, that's it. It has to be something so obvious.
Oh, they didn't agree with me, so I want to get rid of them.
Yeah, that's not going to fly. You're not going to get a second crack at a recommendation by getting a new guardian in. So,
in fact, if you're going to try and remove a guardian, you better be damn sure you know what you're doing and you have good reason, because you could instantly tank your case by doing that.
And that's that meta case that we talk about in the book. You could blow up the meta case because the judge appoints people they generally like.
Or trust anyway, whether they like or not, they trust.
To be the guardian. And if you are taking a shot at them, you better be damn sure that you're going to hit the target, because the judge probably trusts them and thinks pretty highly of them. And you're saying this person's no good. With custody cases, it's just important to know what your goals are and understand if those are achievable. So, for example, I've had more than one young mother say, my husband can't parent the kids. Let's say there's a baby, 1-year-old, this maybe the mom's nursing, and the mom says, my husband's done nothing to parent the children. I do all the work, etc. And that may be true. It might be entirely true. Part of our job is to tell that person, hey, that's not enough. Like, let's say she did 90% of the parenting. And she says, well, I think the status quo should continue and I need to parent these kids. And they like want to fight over it. They say, well, the kids have never been with dad more than one night a week because he works too much, blah, blah, blah. And then the news we have to give them is, hey, the judge is going to let this guy turn over a new leaf. Status quo has some role in these cases, but if the other parent wants to step up, the court's going to allow that, aside from abuse or neglect. Yeah, regular case where the judge doesn't get excited about something bad, the judge is going to give a person a chance. This shocks people, but it's the truth. And they're going to let the other parents step up. In our state, the public policy is that both parents should be involved in the children's upbringing. The research backs that up too, that the more both parents are involved, the better, blah, blah, blah.
And the status quo used to be that you were married. So you had a delegation of tasks. So if you can't maintain the status quo for one thing, but not the rest of it. So the things you were doing when you were married are different than when you'd be doing when you were not married anymore. So those roles change as well. Knowing, like you said, what your goals are, and also realistically understanding not just what your wants are, but, having realistic goals. I think that's very important, because once you decide, look, I'm going to take the fight to the other person because I am dug my heels in and this is what I want and I don't care what the reason is, this is what I'm going to get. And you start fighting, you can't suddenly stop and say, all right, never mind, forget all, I did all that. You can't put it back in the box, and you're not dealing with numbers here that have exact values. Nobody really knows the answer. Everyone is just doing their best guess what they think with their experience and their knowledge base. For example, the guardian ad litem has their knowledge base. If they don't work, you'll have what the court calls a custody evaluator. This person in Illinois is appointed under section 604.10, and the court can either appoint the court's expert, or you or the other parent can appoint your own individual controlled expert.
Usually they order that you split the cost of the GAL, usually equally, but not always. And so you're paying for the guardian, that's several $1,000s. The typical rhythm of this is you disagree on parenting, whatever the issue is, you get the guardian, they get a recommendation in writing, sometimes verbally. The party that doesn't like the recommendation, if they really don't like it, they go get the 604 expert, who is usually a psychologist. Can you talk a little bit about the 604 and then what happens at the next level where, like, let's say somebody doesn't like the 604. So how does that work?
So a 604 will give you like a 30-page report, really, that talks about essentially it's like a supercharged guardian ad litem report where they basically go through their interviews. They'll interview each parent multiple times, do home visits, talk to the kids multiple times, observe, talk to collaterals, which are basically friends, family, school, etc. Then they'll write this gigantic report. And then at the very last 2 pages, they'll say, this is what I recommend. And so if you don't agree with that, and they'll send it to the judge, so the judge will see it. If you don't agree with that, you have to file, in our state anyway, in our jurisdiction, you have to file a motion requesting that you be allowed to get your own expert, just so that you can rebut what this court's expert said.
Theoretically, that person will be agreeing with the guardian, you're hoping. Because theoretically, you had the guardian with opinion, let's call it opinion A, and you didn't like opinion A, you want opinion B. So you get an expert, and the 604 says B, which goes against the guardian, and the person who liked the guardian then says, oh, shoot, I need to get somebody to say A again. Now, you don't have to. You could try to lean on the guardian, but a lot of times the lawyer says, oh, you better get an expert.
You fight an expert with an expert, right? So
the psychologist can say, well, this silly GAL is just a lawyer. They don't have my magical training in psychology, blah, blah, blah. So
my medical degree, if they're a doctor,
yeah,
things like
and
that. So
there is something to be said for that. So in the battle of experts, theoretically, the person with the bigger degree is the judge might think they're more believable. So inevitably, a lot of times they go hire this other expert. By the way, you're spending 15 to 25 grand and up per 604.
So you get your own expert. They'll definitely agree with you because otherwise they wouldn't be your expert. And if they don't agree with you, you'll tell them thanks, but no thanks, after they do their thing. But if they do agree with you, then you have them do their report. And now you have 2 experts. And there's cases where the other side will get their own expert because nobody liked what the court's expert had to say. So now you have 3 experts. And sometimes before you get to the expert, or even after, the court, depending on the age of the child in the instances, can appoint a child representative on top of it, or an attorney for the child. And so you have those 2 appointments as well. So now you got a case with like 10 players. And when you look at the front of the courtroom, when everyone is standing up there, there's like 8 to 10 people standing up there, and where are we going, right? It becomes a giant mess.
Right. And to make it clear, this is not every case. This is a subset of cases, but we're just trying to make it clear to you as listeners how this can devolve and what this entails. If there's a custody fight in Cook County, add a year to your case, for sure. Yeah, if not more. And every expert is a minimum of 3 months added to your case. And the cost, we already talked about 15, 25K per. And you know what? The real challenge here is getting your arms around the evidence, because the thing that's hard, right, Rahul, is like ultimately this is all he said, she said kind of stuff.
It really is, unless, again, not looking at a case of abuse, neglect, things like that. It's generally, generic standard case. It's a he said, she said. How do we know? How does anybody know if they're the better parent or not? Sure, I do more things. The state has a bunch of factors that they look at, the judge looks at to determine who weighs the scales more on specific factors and just, all that. But realistically, no one knows the future. No one has a crystal ball. So everyone just tries to do their best. So definitely you have to think about it before you jump in to such a case.
If you go for sole custody or sole decision making, again, it's important to know that doesn't mean the other parent's not going to see the kids. They're going to see the kids 30 to 50% of the time, even if you have sole custody. Sole custody is quite rare. And all that means is you get to decide who the doctor is, and you get to just deal with the school and things like that, and the other parent doesn't. That doesn't mean the parent doesn't get to see the kids. The other parent's going to see them all the time. And also, if you did something really wacky, they could go back to court and say, hey, this decision, yeah, they have sole custody, but this decision's not in the best interest of the child. It's important to know what you're winning here. Now, in a case of abuse or neglect, or somebody uses hard drugs, you have no choice. Those are easy cases. But the ones where, the parents just don't get along well, and I don't want to have to deal with him with the doctor or her or whatever, you better be sure what you're getting yourself into. Because there's a couple things too. And we're going to talk about the washing machine here to wrap this up. But the nature of these cases is verbal testimony. And all of these experts are basing their opinions generally on what people have said.
And you have text messages and emails, but we're categorizing that into statements made by each party.
Yeah, it isn't like there's an objective document other than grades. Like if somebody can say, well, mom's been taking care of the schooling and it's gone in the toilet. Clearly the grades are no good. Well, that's one of the few pieces of hard evidence you might have. Or in an abuse situation, you'll have evidence of injuries or whatever. That, again, those are sort of easy and terrible cases. We're talking about the sort of middle ground where people just don't get along, and they translate that into, well, I want custody. I don't want to have to deal with my soon-to-be ex. the other one hasn't beat up the kids or anything and doesn't yell at them and stuff. So, or they disagree on parenting styles. One person is real food restrictive, wants to control their diet. The other parent doesn't. One parent likes them up, staying up late and stuff like that. People get in their own world, in their own head, where they're like, that's terrible. In their mind, that's tantamount to abuse. And they want to turn that into like a custody case. Well, I had a client like that who shall remain nameless. And we went all the way through trial. And guess what? The dad got custody. And you could say, well, that's because Rafe's terrible at trial. No, thank you. I'm very good at it. What happened was my client ended up looking like she wasn't really truthful. She didn't appear well as a witness on the stand. She argued with the judge a couple times despite all my preparation. And things that she had done as a mother, the judge didn't think were normal or were good. She was very restrictive about their diets and other things. And the judge just didn't like it. The judge thought the husband sounded very reasonable and he was willing to take on the kids. And he ended up getting, back then, we still called it primary. He got primary custody and the kids went with him mostly. And mom wanted sole custody for her. She was adamant about it against my advice. If she settled, she would have had a much better deal. Instead, she got less than that, again, against my advice, because I could see that things that she thought were normal parenting, she read all these books about it with attachment parenting and this other stuff. She nursed a child till the child was like 5, 6 years old, something like that, later than anybody would normally do, right? Well, there are books that say that's normal or that that's the way it should be. When you're married, that's all fine and good because nobody's peeking into your life. But the minute you file a case with a courthouse, the judge and a bunch of other people you don't know get to make decisions about you. And the minute you subject yourself to the jurisdiction of the court, the man or woman in the black robe gets to decide what's going to happen in your life with your kids. And so you better be damn sure when you pull the trigger where that bullet's going to go.
Yeah, they will literally judge your actions.
Yeah, and they're looking at the evidence through a straw, right? I mean, we only spent 5 afternoons of testimony in that case, maybe 6, and that's just a few hours to talk about somebody's whole life. And you can't possibly, with the rules of evidence and everything, get the full picture to the judge, even if you're the greatest trial lawyer on earth. And everything is seen through the filter of the witnesses, the various experts, the GAL. So the judge is hearing from all these people, and you're asking the judge to synthesize all this into some major decision about your life. That's a tall order.
So what's this washing machine, Rafe?
Well, the washing machine it applies to litigation in general, but especially to custody litigation, because the washing machine is when lawyers and their clients just go around and round, kind of like I think of the Three Stooges, for those of you who are old enough to know what that is. But you could Google it if you don't. Watch some of their stuff on YouTube. Comedy act that would literally like slap each other and poke each other in the eye, and it was like slapstick kind of stuff. So one parent says, the other parent's no good. And then the other parent goes, that guy's no good. And they go back and forth, poking each other in the eye, emailing the GAL, telling them that the other person's no good and here's the bad stuff they did. And it's never really rises to the level of abuse. It's just kind of maybe lousy parenting. Dad had the kids up too late on the weekend. You gave them Cheerios instead of eggs. All kinds of stuff. You didn't get them to school on time. There's this back and forth that goes on, motion for temporary custody or visitation schedule, and then a motion filed that dad keeps showing up late to pick up the kids, or fill in the blank. It can be any number of things.
And then dad will say, of course, sorry, I'm just going to jump in here just real quick. Well, mom hangs out with the kids and her new boyfriend.
Or she never has the kids ready for visitation when I come pick them up. They don't have their clothes. They don't have their books. The kid can't bring his toys to my house. You get into this whole circus. And this is where it's the washing machine. It's like we go around and you poke me in the eye and then I poke you in the eye. We go around again. And the problem with this stuff is we said it's squishy. It's like holding together a hill of marbles. You're trying to put together all of this evidence and this testimony, try to make something out of it. And then like when you let go, the marbles roll apart again. It is really hard for anybody to get their hands around the truth, if you call it that, in these situations. And so what can happen is it's just this around and around and around. And we get the GAL. They do their investigation. Now we go around, we don't like it. So now we got to appoint a 604 and 25 grand, 9 months, 6 months go by. Now we don't like that. We go around again. We're going to get the other 604 expert. Now we have 3 opinions, or as you said, could be 4 opinions. It just goes around and around again. And it's at the expense of the parties in the case. The lawyers aren't paying.
At the expense of the poor kids. They got to go talk to all these people.
And the kids are waiting for this to be over with because divorces are bad. Everybody's stuck in the middle. So my caution to people is it looks neat and tidy. This world is not a laboratory setting. You think when you know I know the facts. I know the judge will side with me. I'm in the right. You better be sure about that. And the evidence better be great, because I'm telling you, it never quite comes out the way you think it is going to. And then things change along the way because these cases take a lot of time. So you think it's going your way and then it doesn't. So it's one thing, like I said, drug abuse, neglect, whatever. Those are easy cases. I mean, they're tough cases, but they're easy factually. We're talking about these kind of in the middle things. And I'm just saying, if you're interested in doing this, you really need to get good advice and make sure you know where you're headed and what this is going to take. Because I don't think a lot of people really understand at the outset where they're headed with this and how this all goes. And they say, oh, the expert says that I should have custody, not my wife. And that's going to trump the guardians thing. Oh, will it? Is it going to really? You don't know.
Right. And it's never a sure thing. I always tell people, I like to use the example of, if someone likes sports, I'll say, well, who's your favorite sports team? And maybe it's a really crappy team, right? If you're a Chicago Bears fan, for example. But let's say it's like a Kansas City Chiefs, right? How much money are you willing to put on it that they'll win the Super Bowl this year? Are you going to put your life savings on it? Are you that confident that you're going to win? Or are you going to say, okay, tonight's game, I know they'll win. I'm almost positive they'll win, but I might not. So again, same thing here. There's no mortal luck. Regardless of how much evidence you have, how likely, how sure you are you're going to win, you're not making the decision. Your attorney's not making the decision.
If we get any message across, it's be very careful getting into this kind of litigation. Get really good advice from a lawyer that's been doing this for a long time and can give you some real perspective about what you're getting yourself into, because what seems obvious to you, and you may well be right even. And I've had these conversations and consultations where the client's like, dad's not good at parenting. He drinks too much. But did he drive drunk with the kids? No. Okay. Well, does he neglect them? Not really. All right. He doesn't feed them real well. He's not good at cooking and stuff like that. Or he swears too much. You and I may agree that that's not acceptable parenting or whatever, but the bar for parenting in the courthouse is very low. And I don't think people understand that.
And judges will do what they can to keep family together insofar that they're not looking to have parents not see kids. They're looking to see how they can see kids. That's
right. The default is let's get the other parent involved with these kids, not the other way around.
Yeah. Exactly. They're not looking for reasons to say, okay, to exclude them. So
thanks for listening, everybody. We always appreciate you listening to our show for I Just Want This Done. And from STG Divorce Law in Chicago, I'm managing partner Rayford Palmer. And with me, as always, is partner Rahul Iyer. Thanks, Rahul. And everyone have a great day. Take care.